And now it's time for another case law update. Today's update covers Anadarko versus Alternative Environmental Solutions, Inc., a breach of contract and choice of law dispute arising out of the Fifth Circuit Court of Appeals. Let's dive in. Anadarko and AESI entered into a master service contract, the MSC, in 2008 for environmental remediation services. The MSC contained a choice of law and governing law provisions, stating that any litigation would take place in Harris County, Texas, and that the MSC would be governed by Texas state law. The contract also stated that AESI agreed to defend, indemnify, and hold harmless Anadarko from any claims arising from AESI's violation of the law. At the time, Stanley Pulowski and Brandon Cork owned AESI. From 2008 to 2012, AESI performed work for Anadarko in Wyoming and Louisiana. In 2012, Pulowski discovered that Cork and other AESI employees had fraudulently overbilled Anadarko by submitting inflated invoices. Pulowski notified Anadarko, and Anadarko terminated the MSC. Pulowski then sued Cork in Louisiana, and Cork relinquished his stake in AESI. Afterwards, Pulowski amended the lawsuit to sue Anadarko and one of its employees, claiming the employee was complicit in Cork's scheme and that Anadarko was vicariously liable as well. After years of litigation in state court, Anadarko filed a lawsuit in the Southern District of Texas. Anadarko sought a judgment that AESI must defend and indemnify Anadarko from the claims in the Pulowski lawsuit, as well as damages in the form of past and future attorney's fees for both the original breach of contract suit and the current suit. So basically, what is happening here is because of this indemnity provision, Anadarko is getting reimbursed for damages and fees by AESI for a lawsuit by the owner of AESI against Anadarko. The district court applied Texas law and awarded summary judgment to Anadarko, and AESI appealed to the Fifth Circuit. First, AESI argued that Louisiana, rather than Texas law, applied to the case and urged the court to apply the Louisiana Oilfield Anti-Indemnity Act to render the indemnity provision void. The court determined that Texas law, rather than Louisiana law, applied to the MSC. The court explained that a choice of law provision governs unless another state, in this case Louisiana, had a more significant relationship with the parties, a materially greater interest, and applying the chosen law would violate Louisiana policy. AESI argued that the actual work was done in Louisiana rather than Texas, so Louisiana had a more significant relationship with the parties. The court responded that although some of the work was performed in Louisiana, most of it was performed in Wyoming. The court went on to conclude that Texas had a more significant relationship and material interest because the MSC was executed in Texas and meetings regarding the remediation project were held there. Additionally, applying Texas law would not violate Louisiana public policy. Second, AESI argued that MSC's indemnity provision was void because it is against public policy under Texas or Louisiana law, as it supported an illegal act by Anadarko's employee. The court concluded that even if someone committed fraud arising out of a contract, the contract itself is not an agreement for an illegal purpose. The claims for which Anadarko sought indemnification arose from AESI's violation, not from its employees' alleged fraud. This fell squarely within MSC's indemnity provision, as the Pulowski claim against Anadarko arose from AESI's violations of the law. So why does this matter? This case illustrates the real-world impact of choice of law provisions and how courts analyze which state's laws apply when work is performed across state lines. This case also underscores the importance of a strong indemnity provision, as it can protect you and your company from litigation arising from a counterparty's wrongdoing or your own. But also, check your contracts and their indemnity provisions before you file suit. You never know, you might end up paying for your own lawsuit. That's all for today. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help with this update.